May I please, my lord?
Yes.
Lordship, I beg to mention item number 14. Hearing item 14 on behalf of my colleague KV. I have taken the consent from the other side. If this matter can be listed after a week.
Okay. Mr. Angami, appearing on behalf of Mr. KB Angami, government advocate for the respondent. Oh, criminal BP. No? On with the consent of the Land Council for the petitioner, praise for listing this matter after a week.
After a week, my lord.
The prayer is allowed. List this matter after a week.
Lordship, I also beg to mention item number 19. This mention also is made on behalf of my colleague KV. If this matter can be passed over for the day, my lord.
Okay. Let's pray for by. Your okay, Miss
Rebecca,
Council for the petition appellant is present. Mr. Angami, Lana Council for the opposite party respondent. Praise for listing this matter.
Tomorrow, my lord, pass over.
Pass over.
Yes, my lord.
No, so this is hearing.
Yes,
Tomorrow's cause list already prepared.
lordship.
Cannot be included. So next week.
Lordship. next week.
Okay. Praise for
After a
listing this
week.
matter after. Huh?
After a week.
After a week. The prayer is allowed. List this matter after a week. Okay.
I'm deeply obliged.
Mr. Lordship.
Yes.
Lordship, I beg to mention item number 6, Lordship. 6 on behalf of Ajumli Lordship. But this matter can come up on Friday, Lordship.
So the petitioner also, I think, have to file additional affidavit here.
No, Lordship, I won't be filing, Your Lordship.
No, you're not going to file.
I won't be filing.
There was a prayer, I think, earlier.
That's on the last occasion, yes, Lordship.
Okay.
But then I've submitted before the court, Your Lordship. So I'm filing the court.
So you have no objection there.
Yes,
So
Lordship.
please,
Monday, Tuesday.
then in that case, this is ready for hearing, I think.
Yes, Lordship.
Lordship.
Since the counsel for the state is absent to the honor.
Lordship.
Okay.
So I pray that the matter may be
Land
fixed on coming Tuesday.
Mr. Supamati, Walling Land Council for the petitioner is present. Miss. So you are appearing on behalf of
Ajumli Lordship.
Chungni Land Council for the
State
state
respondent.
respondent. Praise for listing this matter after
On Tuesday, Lordship.
on Tuesday. No. Tuesday means next Tuesday.
Yes, Your Honor.
Next Tuesday, Lordship.
Okay. Next Tuesday. Okay.
Obliged.
We'll say next week only.
Yes, Lordship.
So next Tuesday, then it will come as a fixed item. And unless you are ready, fixed item, fixing the matter is of no use. Yeah?
Yes,
Next week. Prayer allowed, list this matter after a week. Okay.
obliged.
Lordship, I also beg to mention item number 5, Lordship. 5.
Item number
5.
5,
On behalf
return
of
service is still awaited here.
Lordship. On
No
behalf of
point of
Livica
course.
Lordship.
On behalf of,
Livica Lordship.
Lordship, let the matter come, Lordship. My senior will be appearing.
when?
Let the matter come especially.
Okay, but return service awaited here, I've seen.
That is right, Lordship. My
Okay.
senior will be.
So let the matter come.
Yes.
It will be adjourned only. Okay.
Lordship, if I may be pleased to mention item number 8, Lordship.
8.
Lordship. On behalf of Viju Momi, Lordship.
Okay.
This matter can come up after 3 weeks, Lordship.
So who is for the petitioner here? Mr. Philip Lawrence.
This,
So we'll pass order, let the matter come.
Lordship.
Hmm.
Please, Lordship.
Please, my lord.
Yes.
My lord, I may be allowed to mention for item number 7, Lordship. I'm yet to file my affidavit in reply. Lordship, 2 weeks may be granted to me.
Yes, you have not yet filed.
Yes, Lordship.
Mr. You are,
To show all of my lordship.
okay. Land counsel for the petitioner is present. Miss, her name, huh? Land counsel. Government advocate is present on behalf of the state respondent. Stop. Mr. His name, huh? Praise for further, how much?
2 weeks time.
2 weeks time to file affidavit in reply. The prayer is allowed. List this matter after 2 weeks. Okay.
Obliged, Lordship. May I please, your lordship?
Yes.
Lordship, I beg to mention hearing item number 13.
1-3.
Yes, my lord. Lordship, on consensus, all the parties, we are seeking for adjournment for 2 weeks.
Here probably you have also prayed for. So counter also not filed, I think.
Lordship,
it is-
hearing item number 13.
13, why it
Yes.
has been listed, I do not know. Counter also not filed, I think. You have received the counter?
Lordship, this is a first appeal.
Oh, sorry.
Yes,
Oh, this is- I think the opposite side then prayed for filing something. Okay, Mr.
instruction. Lordship, I'm appearing for my, on behalf of my senior, Lordship.
Okay, appearing on behalf of city,
Yes, my lord.
Okay, Lord Counsel for the Lord Counsel for the appellant. Praise for
2 weeks, Lordship.
listing this matter after 2 weeks. Miss, you are for
The respondents, your lordship.
respondent number, private, sorry, okay, Miss so-and-so appear on behalf of, sorry, respondent number. Sole respondent, okay.
Yes.
Is prayed for by the Lord Counsel for the appellant. Please this matter after 2 weeks. Okay.
Pledge, Lordship.
May I please, your lordship, I beg to mention item number 18.
Yes.
Your lordship, the hearing was concluded on 6 May and it was listed today just for clarification. So if the matter could kindly be upgraded as the first hearing matter today.
First hearing.
Yes, your lordship.
Yes, this was to be heard. For further hearing.
Yes, your lordship, for further hearing.
Okay, I think the other matter adjourned. Okay.
Yes.
Yes.
It is Lordship. Lordship, I beg to mention item 15, 1-5. On behalf of Mr. Taliao
Yes.
for the appellant.
Hmm.
Lordship, let it come up after 2 weeks, Lordship.
Mr. Procedural for the Lord Counsel appearing on behalf of the appellant prays for listing this matter after 2 weeks.
Lordship.
The prayer is allowed, list this matter after 2 weeks. Okay.
Lordship. Lordship, I also beg to mention item number 4. Item 4, I'm for the respondent. Lordship, the parties are,
It was amicable settlement was on process.
yes, on process.
What
but
happened?
In between, Lordship, one of the director, he passed away.
Oh,
So due to that, we could not expedite the agreement,
okay.
the settlement. So Lordship, may kindly grant me 4 weeks time, Lordship. In the meantime, we will try to
Okay.
settle, Lordship.
Lordship, I am appealing for the petitioner, Lordship. Only difficulty is that the matter was, it is a fact that material was jointly compromised.
Hmm.
And we have prepared the memorandum of understanding and sent them for signing in January.
Okay.
But till they are postponing the matters. So
Okay.
my learned friend's statement may be recorded. That they are going to settle the matter.
Okay.
Otherwise, hearing will be done, Lordship.
So, who expired, you said?
One of the directors of the company,
Okay.
the Global Ceramics Private Limited, one of the directors he passed away.
Procedural for the Land Council for the petitioner. Some said one of the directors of the company expired, due to which the process for settlement could not be finalized. And praise for listing this matter up, praise for further 4 week times.
Lordship.
On 27 Lordship, June.
Staff, Mr. P.V. Paul.
No, I am for Azteca, Lordship. For petitioner, Lordship. He's in the wrong side.
Proseco is for the respondent.
For respondent, Lordship.
Sorry, respondent, huh? Okay, Mr. S. The Galana Council for the petitioner is also present. He is prayed for by the Galana Council for the parties. List is matter.
On
4 weeks.
27 Lordship, June.
27 June.
June.
Okay,
And Lordship, his statement may be recorded, Lordship.
recorded.
Yes.
Hmm.
Well, he will positively done if they compromise. That has
It will be done only.
Yes.
Yes.
Obliged.
Yes. Otherwise, Lordship, under net, if they fail, the hearing will be started. Lordship. That observation may be given.
Let us see. So since you also agree that it is under process,
Yes, that is process,
It is
but
always
we are
better.
lingering, Lordship. That
it is always
difficulty.
better.
We are
Since you
come
have
from
already
outside.
prepared the MOU also,
Yes.
memorandum, sorry, memorandum.
Yes. That has sent to the then in the month of January, and the
Hmm.
director and their director was expired in the month of October 2023.
No point postponing. Instruct them.
Lordship.
Yes.
Lordship.
Okay.
Obliged. Obliged, Lordship.
Please, Lordship.
Yes.
Lordship, I beg to mention item number 11, orders. Lordship, here the office note dated 11/5/2024
We'll pass over that, let it come. Notice,
is
return
written
notice is
unserved.
awaited. Oh, unserved,
Unserved. Lordship, this is the second time.
second time.
So,
We'll pass over that, let it come.
Lordship,
Okay.
no,
Mm. Yes,
May I please your lordship? I
right,
beg to mention hearing item number 15 on behalf of my senior Mojamil. That this matter be listed after 1 week.
already mentioned,
Hearing item number 15.
yes, on the consent of the party, probably.
I've taken consent from the.
You have also taken
petition.
consent, it's good. So, yes, it is already mentioned. When do you want, according to you?
After 1 week.
I think probably 2 weeks.
Lordship, 2 weeks.
So you will,
2 weeks.
we'll make it a 1.5 then. Okay,
Lordship.
okay.
Like, Lord.
May I please, your lordship?
Yes,
My lord, I beg to mention item number 10. Your notice is still awaited. Therefore, I pray
return
that
service still awaited. Okay, Miss
Honbeni,
Parent Counsel for the petitioner is present. Staff, the office note reflects that the return service is still awaited. In view of the above, this is matter after
3 weeks.
3 weeks. Okay,
Oblige, my lord.
May I please, your lordship? I beg to mention item number 12. Your lordship, service upon respondent 9 is still awaited.
yes. Yes. Miss Miss
And solo.
and Solo, Lana Counsel for the petitioner is present. The office not, you are for?
Respondent number 2.
Okay, Mr.
Lordship, I'm appearing on behalf of my senior, Mr. Sindianga.
Okay, you
So
are
I pray that
Mr.
his name may be reflected on the order.
Hmm?
I pray that his name may be reflected on the order.
Okay,
Presently, he's in court 1.
okay. Mr. You are Mr.
Manan.
Appear on behalf of the Lana Counsel for the respondent. No?
Respondent
Respondent,
number 2.
oh, sorry, Mr. Santianger. Santianger. Appearing on behalf of Santianger.
Yes. my lord.
Okay, Lana Counsel for the respondent number 2.
1, 2, and 3, your lordship.
1, 2, and 3. Stop.
Easy.
The office note date we do not know. Kindly see the date, no? Date. Yes, keep it
26.
kept, no? When?
26/4/2024.
26/4/23 reflect that the service upon the respondent number
9.
9 is still awaited. Stop. In view of the above, list is matter after
3 weeks, your
3
lordship.
weeks. Okay.
Much
In view of
obliged.
the above and as prayed for by the Lana Council for the petitioner, no? List is matter after 3 weeks. Okay.
Much obliged.
For motion item numbers 1 and 2.
May I please, your lordship?
Yes.
Lordship, IA 70 is to implement Sri Vicky Kenya as respondent number 4, your lordship, as he has been recently posted in the office of Home Commissioner.
Okay. So earlier,
Abhijit Sinha, Sri Abhijit Sinha.
okay, so he,
He will
has-
be in respondent number 4, your lordship, this new incumbent.
okay. Miss.
Vicket Sono.
Wicked Sono, Lana Council for the applicant. Also heard, Mr. M. Tim Song, Lana Council for respondent number
Respondent 1 and 3.
1 and 3 staff. Tara, this is an application praying for leave of this court to implead Sri Vicky Kenya, who has been recently posted in
In the office of
as
Home
in
Commissioner.
the office of home, he has been posted as
Home Commission.
Home Commissioner.
posted as home commissioner. Commissioner, Government of Nagaland, in place of
Sri
Which is-
Abhijit Sinha.
in place of the earlier incumbent, Sri Abhijit Sinha, who has been transferred.
Transferred
Yes.
Okay.
out of state,
Who has been transferred
out of state.
out of the state staff. The Honorable Counsel for the respondent has no objection. Has no objection, staff. Accordingly, the prayer is allowed. The prayer for implementing
Lordship, you be
Sorry.
respondent number 4
Wike Kenya,
as respondent number 4.
the Commissioner, Home Commissioner, Government of Nagaland, is respondent number 4,
Yes, Lordship.
staff. Then you have to take a step. Yeah.
Lordship, petitioner has to file a amended copy.
Yes,
You
sir.
file amended the course title also.
Yes, Lordship.
The petitioner shall file amended course title by implementing inserting the newly implemented Home Commissioner as respondent number 4, staff, and staff. With the above this, I stands disposed of.
Yes, Lordship.
Mm.
Lordship, and
Let
IA number 71, Your Lordship. This is to amend the petition, Your Lordship. There has been an inadvertent error in the prayer. In the order date as well as the number of the petition, Your
Okay,
Lordship.
Miss
Viketsono.
Kitsono, counsel for the applicant petitioner. And also Mr. Dim Song, counsel for the respondent number
120.
1 and 3. Staff, this is an application. Paying for leave of this court to amend the petition in civil original petition contempt number 39 A to 2019. What is the amendment? What you want to
There-
amend?
There has been an error in the date of the
Okay.
order as well
Okay.
as the number of the petition
Is there?
and the newly implemented.
The Honorable Counsel for the petition submits that there has been an error.
Yes, Your Lordship. Inadvertent error.
Inadvertent error with regards to the date of the
Order.
orders as well as the number of the petition, and praise for allowing her to correct the same by amending the prayer portion.
Yes, Your
It's a
Lordship.
prayer portion
Yes,
only.
yes, prayer
Paragraph number
portion.
2 and 3. Yeah,
Hmm?
seeking for amendment of paragraph number 2 and 3.
Oh, paragraph number 2 and
2
3.
and 3.
Okay, stop. The Honorable Counsel for the Honorable Counsel for the respondent has no objection. Accordingly, the prayer is allowed. The applicant petitioner is allowed to, permitted to amend the course title of the petition in terms of the, no,
Lordship
No,
is in
this
the
is-
prayer only.
no, this is in the prayer.
Yes, in the prayer only, Lordship.
In the prayer.
The order date there's been an error in the order date.
They're permitted to. Amend the prayer.
Yes, Lordship.
Where from you're saying paragraph 2 and
Page number 6.
Page number 6 of prayer.
No,
That also?
as per the IA, your lordship, that,
Okay, no,
Yes.
not paragraph. It's only prayer. Her statement is in paragraph,
yes, your lordship,
but then as her prayer is only to amend the prayer portion.
yes, lordship,
The prayer portion, date and the
petition number.
There is
petition
IA
number.
71, but,
Yes.
so if I'm not mistaken, your worship, the prayer column is, page number 5 and 6 to amend the petition as mentioned in paragraph number 2 and 3 of the instant application.
Where-
That is
Yes.
page number 6, IA 71,
6.
page number 6.
Amend the petition as mentioned in
mentioned in
no.
Yeah, that's
Oh, so
right.
yes. It's mentioned in paragraph 2
Yes.
and 3 only.
Of this IA, your lordship,
Of this, in the paragraph 2 and 3, she has stated that allow her or permit her to
Okay.
amend. Okay. Delay that one. The prayer is allowed. Huh? The petitioner already recorded the permitted to amend the cost. Amend the. It's not a course title. The prayer.
prayer, your lordship.
Okay. Amend is prayed. Huh? Okay. Then in that case, since you are also the course title also you have prayed for
Yes,
and also this,
yes,
then
the newly
entire I
completed.
think then this page also. So first page course title and this prayer portion also you are going to replace it,
Yes,
isn't it?
yes, your
So then
lordship,
amended petition is to be filed.
yes, your lordship,
The petitioner, the applicant, petitioner shall file the amended petition, accordingly. In the main, with the above this, IA stands allowed and dispose of. And in the main,
yes, your lordship,
are Miss Sam, and Mr. for the respondent staff, in view of the order passed in IA number 70, 2024 and 71, 24, whereby the petitioner has been allowed to amend the course title as well as the prayer. The petitioner shall file amended petition staff. The petition shall also serve the amended petition to the copy of the amended petition to the respondent and the newly impleted respondent, and take steps upon the newly impleted respondent number 4 within a
1 week,
period of 1 week from today. Then by a registered post with AD within a period of 1 week from today. Establish this matter after 4 weeks.
yes,
Okay.
Your worship, I have a prayer.
Yes.
At this stage also, I'm still disabled because of the declaration of the ULB election. So mode of conduct is already will be exist till 29th of this month. So this matter may be come up after first week of July because you see those.
You have any problem?
ULB election
no, lordship,
Okay.
deputy commissioner, they are the returning officer.
Okay,
And in the
okay.
meantime, in
Okay.
this matter also, deputy commissioner has to play a role.
Okay. So the land council for the party submits that due to the election, the respondent will be busy till the month of June and prays for listing this matter in the month of the first week of July. The prayer is allowed. List this matter during the first week of July accordingly. Okay.
yes, your lordship,
From the supplementary cost list for motion item number 20.
Your lordship, during the pendency of the writ appeal, the government respondent produced the office letter dated 2nd June 2023, page number 49, annexure 7 of my writ, the contempt petition. Written by the Additional Secretary, Finance Department to the Home Commissioner, Nagaland, Kohima, stating that the appellant will be pay back wages.
What is this, page 49? Annexure 7, what is this?
This is, Your Lordship, this is letter of, additional secretary letter,
Hmm?
Finance Department, written to the Home Commissioner, stating that the petitioner will be paid back full back wages. That is from the date of his reinstatement.
Okay,
That is for July 2011. And Lordship, since this is placed on record during the pendency of the writ appeal, the grievance of the appellant has been solved. On this basis, the writ appeal was closed on 15 November 2023. That even though the appellate court passed the order dated 15/11/2023 in presence of the counsel for the respondents, the appellant counsel, as a measure of abundant caution, furnished the Honorable Division Bench order, Annexure 9, page 53 of my contempt petition. It is very unfortunate that even after giving undertaking by the office letter 2nd June 2023 to the Honorable Court that the back wages will be paid, which was totally misled intentionally, and the appellant is not paid back wages till date. Hence my contempt petition, Your Lordship.
okay, hard miss,
Reconnaissance.
counsel for the petitioner. Where in the order of the High Court reflect that he has undertaken to release, which
Oh,
para?
yes, Lordship, page 25.
Yes,
Annexure 9 of my writ appeal.
25,
The undertaking is in Annexure 7, Lordship,
page
49, Your Lordship.
okay, so where is where in the order of the High Court this has been reflected?
Annexure 8, order dated 15 November 2023.
Para?
Point number 4 and 5, Your Lordship. Page 51.
50?
51. Point number 4 and 5. Point number 3 is, Your Lordship, the government placing the record before the, or Your Lordship. 2nd June 2023 letter.
Okay, this is an application. For initiation of contempt proceeding under section 11 and 12 of the Contempt of Courts Act 1971, read which the Contempt of Court Gauhati High Court Rules 1977 and Article 215 of the Constitution of India. For non-compliance of the undertaking So what was the undertaking this?
This is the letter written by the additional secretary to the Home Commissioner stating that the petitioner has been reinstated with retrospective effect and she's entitled to salary of the living period from 4 July 2011. On this basis, the writ appeal was closed, Your Lordship.
Made before the court, huh? Stop, huh? The case of the petitioner is that during the hearing of writ appeal number 4, 2023 on 15/11/2023, comma, the respondents has placed a copy of the communication number FIN/ESTT-1/88/court capital /19 dated 02/06/2023, stating that since the service of and stated that since the service of writ petitioner, writ appellant dash writ petitioner has been reinstated with retrospective effect, comma, the state government has taken a decision that the writ appellant dash writ petitioner is entitled to salary of the relevant period on and from 04/07/2021. So till date you have not given.
Yes, Lordship. I was till my reinstatement, I was not given.
Hmm?
Till 15 August 2019, I was not given. From
Till 15?
yes, Lordship.
Rest given.
Yes, no, Your Lordship. Till my cancellation of regularization order, till reinstatement, I was not given. That is from 4 July 2011 to 15 August 2019.
Where have you stayed?
Yes, Lordship.
So who is this?
It,
Who is this? Why it has written? Probably
Your Lord-
aggravated.
My reinstatement is in page number 30. That is 16 August 2019. And
Page
page 30, Your Lordship.
30. What is that?
Annex 4. That is my reinstatement order. Since I was reinstated from 16 August 2019, I was supposed to receive the till 15 immediate date prior to the date of my reinstatement, Your Lordship.
So what is your grievance now?
Lordship, when I filed my grievance now is to pay me back my back wages since I was reinstated to my service. Your Lordship.
However, the respondent has failed to pay the back wages of the petitioner till date.
Yes, oh, in my writ appeal. that
Entire
they pay-
back wages or what?
Yes, Lordship.
Okay. Hence this contempt petition stop. Issue notice returnable by 4 weeks. Stop. The petitioner shall take steps upon the respondents by a registered post with AD within a period of 1 week from today. Stop. List this matter after. This is the authorities are, this is also invoked. No,
Uh, Your Lordship, this letter is written by additional
deputy
secretary.
commissioner are also involved. So list this matter after 6 weeks. So what is this? You see, you have given notice and it appears.
Yes, Lordship, for compliance of this court order.
So who is this? The advocate written, I direct. Advocate probably has no right to give direction.
Oh, no, Lordship,
care,
after
take care.
the writ appeal was closed. Yes, sir.
See the notice, page 59. Therefore, I direct you to immediately. So this, take care of this such language
Thank you, Lord.
while using the right the official letter.
Lordship, much more.
Yes.
For admission, item number 3.
Yes, Lordship.
Yes.
Lordship, we have received the paper book.
Yes. You have received the
Paper book, Lordship. So it will come up as in the usual course of hearing, Lordship.
Yes.
And for the petitioner.
Mr. Paseka Fotila and counsel for the petitioner is present. Miss. So her name appear on behalf of the state respondent. Okay, stop. It is submitted that you have also received the paper book? No. It is submitted that they have received the paper book. Whether this admitted, this is okay, criminal petition. Okay. They have just
It's
written
ready
the
for
paper
hearing,
book
Lordship.
and praise for listing this matter
In the usual course of hearing.
in usual course.
Of hearing, Lordship.
Okay. List it accordingly. Okay.
Obliged, my Lord.
For admission, item number 5.
Maybe, Your Lordship.
Yeah.
Lordship, I'd like to mention on behalf of Liviga, Lordship, if this matter can come out after 2 weeks, Lordship.
Lordship.
Yes, return service submitted. Okay. Mr. Fosek, what you are appearing on behalf of?
Mr. Lima Upang.
Okay. Appear on behalf of Mr. Lima Wangpong, line counsel for the petitioner. Miss
Yes, Chang.
appear on behalf of Miss Libika, line counsel for the respondent. Respondent? All the respondent.
Lordship. It's a contempt petition, so
Libika is
there are two, yes, there are two contenders.
represented for Libika for government advocate. No. Just a minute. It's not a state respondent, it's contempt only. Probably represent for respondent number. Then it's one only. I think respondents. Okay. The office note dated. The office note reflects that the service report That Libica is representing. There is only respondent number 1 and 2. And if she is representing, then service is not awaited, return service is not
Yes,
awaited.
Lordship, yes, Lordship.
Okay. Then as prayed for by the Rani Council for the parties. List this matter after
2 weeks, Lordship. 2 weeks.
2 weeks. Okay.
Obliged, my lord.
Obliged, Lordship.
For admission, item number 8.
May I please, Your Lordship?
Yes.
Lordship, I appear to mention on behalf of Vision One, Lordship. If 3 weeks' time may be granted to me, Lordship.
None appears on behalf of the petitioner. Stop.
Lordship. Lordship, service copy is not served to me, Lordship.
Okay. Appearing on behalf of Mr. Reed Zimomi, Planet PP. Praise for listing this matter
After 3 weeks, Lordship.
after 3 weeks. What is not served to you?
Service copy is not served to me, Lordship.
Okay. After 3 weeks. She further submits that the copy has not been served to the PP staff. The petitioner shall furnish a copy of the criminal petition to the respondent within a week from today. List this matter after 3 weeks. Okay.
Obliged, Lord.
For orders, item number 9.
None appears on behalf of the parties. Case stand adjourned. List this matter after 3 weeks. After 4 weeks.
For orders, item number 11.
May I please, Your Lordship?
Notice return answer.
Yeah, Lordship. And this is for the second time, Lordship.
So then,
So I pray that I may
so
be
you
allowed
have
for
to find out the correct address.
Lordship, we don't have any other address besides the one which is reflected on the FIR.
It's your case, then you have to find out. What do we do?
Lordship, I may be allowed for paper publication, Lordship.
That's better. Alternative. Mr.
Jamir.
Jamir, Land Council for the petition. Hard Mr. Jamir, Land Council for the petition, and Mr. Angamin, Land PP. This is okay for the state staff. The office note, dated. This is two. This second time,
Second time.
reflect.
First was 27/03/2024.
That the notice is issued upon the respondent number 2, return answer with a remark. RTS, no such person in the address. Stop. In view of the above, the Land Council for the petitioner prays for permitting him to take steps upon respondent number by
Respondent number 2.
respondent number 2 by a substitute service of by publishing in the local newspaper. Where address is?
Dimapur.
So, okay, the local two or one, 2 local newspaper.
Lordship. 1, Lordship.
1. Normally 2. where one paper covers entire.
Lordship, Nagaland Post.
Yeah.
Covers. Nagaland
Covers,
Post.
huh?
Widespread circulations are there.
Sometimes it happens that the person sees only one paper.
Yes, my lord.
Ah,
Then it
So,
will be a
to be
difficulty.
the safer side,
Yes.
two newspaper,
Lordship.
newspaper by fixing. Oh, sorry, two newspaper. Two newspaper returnable by. Date when. By fix by indicating when.
Lordship,
the
within 1
news
week,
appearance.
within 1 week, I will take the steps, Lordship.
When to be listed, because you have to indicate the date of his appearance in the court.
Lordship.
Mm.
Lordship, since the leading counsel is from outstation, Lordship, may I suggest a date, Lordship?
Hmm?
May I suggest a date?
Yes,
June,
June,
June 10.
June 10. It's May.
Now it's May.
This is May. No, paper publication. So June, say 14th, no?
Lordship, paper publication, I will take the steps within 1 week, Lordship.
Within a week.
And I'll file a compliance affidavit.
Okay. So June 10. Okay,
To be listed on June 10 next date, Lordship.
okay, indicated that he'll take steps within a week from today, huh? By indicating the appearance of the respondent before the court on June 10. Stop. And file the compliance report.
Lordship.
Okay. List the matter on June 10. Okay.
Obliged, Lordship.
Obliged, my lord.
Yes.
For hearing item number 18.
Oh, how many? 16 is there.
Lordship,
Yes. Okay.
item 18.
So
No, please, your Lordship.
yes, you are for?
I'm for the respondents, only respondents, Lordship.
Okay, respondent. And who is for the petitioner?
P.P. Paul was Mr. P.P. Paul was for the petitioners.
Okay.
Lordship, because of some pressing difficulties, I'm not able to appear physically.
So Paul is also not there, it appears.
I believe he's in another court.
Another court.
Yes, Your Lordship.
So he is
Lordship.
Your Lordship, Sir Foseko is appearing on behalf of PB Paul. He's present in court today. Yes, Your Lordship.
Okay.
Lordship, the hearing was concluded on the last date, and Lordship, the matter has been listed if your Lordship requests certain clarification.
So we can wait for some time?
Yes, Lordship.
Okay.
Yeah.
For hearing,
Pass over. So or what? You want some other date or what?
No, Lordship, can be done today itself. No,
Okay.
for me, it is,
The item 16 will take time.
because since it is a hearing is already concluded, Lordship. If it is kept for too long again,
It will be difficult.
yes, Lordship. Mr. Seko was supposed to appear, I was told.
Okay. Okay, we'll wait for some time then. Okay. Yes, next item is,
Lordship, Seco is coming.
okay.
That was
Yes.
his lordship.
Second.
Lordship, I believe my seniors argued the matter, and the matter is, I think,
So this
heard
is,
at length, concluded, I believe. If any clarification, lordship,
what was this matter about? Just a minute. The what is your case in brief? Mr. MT,
Lordship,
what is your case in brief? You are for respondent.
I'm for the respondent. Lordship, my case in brief is that there's absolutely no prima facie case. Because, Lordship,
Yes, you represent the. So this is person, I thought it was association. Who filed this? Kukami GB?
lordship,
no, Lordship, this has been, Lordship, let me just refresh the memory of this honorable court.
Yes.
Lordship, this is a tussle between two parties for the office bearers of the Western Sumi Kukami Hoho. Both the parties are claiming that they are the validly appointed office bearers. And while I was in office, the present petitioners filed a suit seeking that I should be restrained from functioning as the office bearers, the president, the vice president, and the general secretary. And an injunction application was made, and that injunction application was allowed. I filed an appeal before the district judge, and the district judge has reversed the order and has asked me to and allowed me to continue. Their case is that they have been validly appointed in terms of the Western Sumi Kukami Hoho. My case is that, Lordship, there's a process for selection as per the constitution of the Western Sumi Hoho, and the previous tenure the previous tenure of the office bearers had expired in 2019, yet they they did not want to relinquish the office. They continued, and therefore complaints were made, but they were not appointing the nominating committee in terms of the constitution. So the Western Sumi Kukami Hoho is an affiliated body of the Western Sumi Hoho. So therefore, complaints were made to Western Sumi Hoho, and the Western Sumi interfered and asked the area people, all the representatives of Western Sumi Kukami Hoho, to select the nominating committee, and nominating committee was selected. Accordingly, we were appointed. Yet the office was not handed over to us, and finally there was an agreement with the previous office bearers that they will continue up to 14 days after the Jubilee period, 12, and that till 12 January 2022, and thereafter office will be handed over to us. Yet they did not do. After they enjoyed the fruit of the agreement, they turned around and appointed the present petitioners, which is totally illegal and not as per the agreement nor as per the constitution. And therefore, and this has been observed, Lordship, but in the learned civil judge, principal civil judge of order, Dimapur,
everything has been considered, and accordingly, the order passed, the injunction order passed by the trial court was reversed. Lordship,
Yes.
the judgment of the civil judge is at page 37. If that is read, everything is clear. Everything would be clear.
Now that your appointment
Yes.
was also probably not fulfill certain requirement. It is the presence of the ex-chairman. So
Because,
what is your submission on that?
Lordship, the previous president,
Previous-
previous president,
So
previous,
as per the rule or
yes,
your
as per the
bylaw,
constitution.
as per the constitution. So his presence is necessary.
That is mentioned, yes. But Lordship, this person
Come about,
was a party to the dispute, and he was not. He wanted. He was not constituting the office bearers, and he was also a contestant. He was also one of the person who contested.
no, because have you given a notice to him?
He contested, Lordship. He also contested. Oh, notice in which case?
Their appointment was in presence of the ex-president, and yours is not in presence of ex-president.
Lordship, what is the thing is the ex-president was also one of the party who contested with me. So they could not have been a part of the nominating committee.
The procedure in such circumstances. What is the procedure to be followed in place of the president who will replace under the circumstances?
Lordship, that has not been mentioned in the constitution, but the house, the members of this organization constituted the nominating committee.
So that amount to illegal because in absence of the president, which is required under the constitution.
Lordship again, but even their appointment is also totally illegal because this president had constituted without the authority.
Not legal, it appears.
He did not have the authority to constitute this body, the nominating committee, because his term had expired. He was no longer the president.
First of all, you have to decide in the meeting or the general meeting or whatever that
Yes.
president is also ex-president is also contesting, and it has to be because unless it is amended or some the meeting the decision has to be taken on that.
Lordship,
So how do you come out of that?
Lordship, Lordship, may I, if I may, Lordship,
Yes.
it's a very peculiar situation where the constitution broke down. The constitution was not being followed.
That's why I'm asking why.
So therefore,
broke down?
Therefore, the House had approved it. After selection of the committee, the representative of all the areas had selected the search committee, and then it was also placed before the House, the Supreme Body, and the Supreme Body approved our appointment.
No, they say that you are not a supreme body.
No, what I'm saying is the House. I'm not the Supreme Body, but the Western Sumi Kukami Ho General Public Body is the Supreme Body.
They are not under your control. Western
Lordship?
They are independent. They say that they are independent.
No. I'm not talking about Western Sumi Ho. I'm talking about the Lordship may kindly come to the annexure. The Western Sumi Kukami Ho. From the search committee. Huh? No. 10. The president but illegally convicted. General body, yes. Lordship may kindly come to page 139 of the name. Lordship may kindly come to page 38, the original.
What is 139? Just a minute.
138, 138 first, Lordship?
Just a minute. 138.
Yes.
What is that?
Lordship, then the translated copy is at page 139. This is the versus Sumi Kokadi.
139.
Lordship has found it.
139.
139, Lordship.
Yes, 139 is there.
139 is the General Conference of the Western Sumi Kukami Hoho, held on 10/7/2022.
Yes,
20.
these so many dates. That is why actually I wanted to record in presence of both the councils, at least the submission.
All right.
For that purpose, probably we have kept. And then in between, I kept busy in dealing with some CAV.
Oh, Lordship.
So,
So, Lordship, then, if your Lordship requests further hearing,
so further hearing, because in presence of both the party, I would like to hear the submission at least, because there are so many things, so many dates.
all right, Lordship. Then
That-
Lordship,
Hmm.
another date may be fixed.
Yes. So in presence of the party,
Yes.
on that day, your submission chronologically, I just would like to take.
Lordship, then in that case, Lordship, I'll also prepare a gist of argument.
Gist.
Convenient, yeah, convenient.
Yes, and then submit that also.
Yes. Lordship, then kindly give me some time, Lordship. I'll be out of station or for my children's educational purpose.
Next week or any.
Next week, till next week, I'll be away, Lordship.
Okay. So the last part of this month,
Lordship, can it be on 30th? If
38th, okay.
30th, can we give it a try, Lordship, if it's convenient for your Lordship?
Yes. So come, you also come prepared with the gist of the case.
Lordship.
So with so many dates, and then the meeting of both the parties imposed. That is why.
Lordship, okay. Lordship, okay.
That 38.
30th.
Mr. Secretary for the Land Council for the petitioner and Mr. Inti Longzin. I've also heard Mr. Inti Longzin, Land Council for all the respondents staff. As agreed upon by the parties. List this matter again on 2024 for further hearing. So come prepare with the gist. It will help me, staff. List of them.
All right.
Like,
For hearing item number 16 and 17.
So this you give me in the chamber, Yes.
My please, your lordship.
Yes, please.
My lord, this FA number 4K of 2014 is directed against judgment and decree dated 31/3/2014, by which a decree had been passed directing the present appellant to to pay the defendant respondent the amount of 70 lakhs after making adjustment of the 40 lakhs already received by the respondent, and at the rate of interest of 18% from the date of filing the suit till the
recovery of the debt. So from the date of the suit till recovery of the debt, the amount of interest is 18% per annum.
18,
14%, not
14.
18%.
as per the
14%.
direction.
Yes. Now,
So the impugn order is 31/3/2014.
The-
2014. Impugn judgment.
yes,
Okay.
starting from 13, should I read the impugn judgment, Your Lordship? Or should I briefly state the facts first?
Okay, at your convenience.
Your Lordship, then I'll make the brief facts of the case
Yes, yes,
because I'll be very brief and to the point,
yes.
except some relevant arguments.
Now, okay, please carry on.
The plaintiff, there are two plaintiffs, Your Lordship. Two plaintiffs. The plaintiff number one is the borrower.
Is there only one judgment and order?
No, there are two.
Two. You are
Well, judgment
impugning,
is only one.
there is only one.
Yes, but
You are impugning
two-
the judgment passed in the counterclaim,
yes. So
not
as-
the judgment.
No,
There is
same
also one
judgment.
judgment,
Same judgment.
same judgment.
Same judgment. But that was because the counterclaim of the respondent has been allowed. A separate appeal also has been filed with the permission of the court. So that is registered as FA 14.
Okay, the brief story
Yes,
will clarify, please.
yes, Your Lordship.
Mm.
The brief story is that the plaintiff number one
Mm.
is the loanee.
Plaintiff number one.
Yes. And
But
plaintiff number two.
Just a minute. Plaintiff number one is here in this appeal.
Yes, in this appeal is Toshi Pogba Longkumer. And plaintiff number two is C. Among Jamir.
So these both are plaintiff, separate plaint,
No,
separate petition,
Same plaintiff.
same petition.
Same plaintiff.
But then
same
there are
petition.
two persons
Yes.
filed the petition.
Yes. Plain also they have filed the together because cause of action is same against the respondent. Now, plaintiff number one is the borrower. And
Plaintiff number one is
plaintiff number one is the borrower.
borrower.
And plaintiff number two is the guarantor who has
But just a minute. Plaint. Plaintiff number two is
the guarantor
yes.
who deposited his original pata into the hands of the respondent for securing the loan in favor of the plaintiff number one.
Yes.
Now, on 13/5/2006, on 13/5/2006, 50 lakhs was borrowed from the defendant at the rate of 8% per month. At the rate of 8% per month.
The interest rate.
Yes. Now, this amount was managed to be obtained by two ladies who are also witnesses in this, one Lily and one Jano Kochu. So through them, this loan was secured. Then after obtaining this first 50 lakhs on 13/5/2006 after 3 months. An amount of rupees 12 lakhs, which is the interest for 3 months at the rate of 8% per month against 50 lakhs was paid. Was paid by Jano Lili, through Jano Lili and
After
Jano
3 months,
Lili.
how much paid?
12 lakhs.
12 lakhs, okay.
Yes. There will be interest for 3 months. Then subsequently, the plaintiffs, appellants,
Hmm.
failed to pay the interest. Therefore, on 30/11/2006, the defendant, respondent, added this unpaid 12 lakhs interest for 3 months and counted as principal. And by adding another 8 lakhs, the total amount of loan was increased to enhanced to 70 lakhs. That is on 30/11/2006.
Hmm.
3 not 30. I'm sorry, on 3/11, not 30. On 3/11/2006.
Just a minute. 2%. So so for this another 3 months, how much was to be paid?
12 lakhs.
12 lakhs again.
Yes.
So since this could not be paid,
the defendant, he compounded this 12 lakhs towards the principal. And by extending another 8 lakhs rupees cash, the total amount of loan was made to 70 lakhs.
eight lakhs was paid in cash.
Paid in cash, and the rate of interest was reduced to 6% per month. 6% against this 70 lakhs. And in this connection, Your Lordship, I'll take Your Lordship to page 56 of the paper book, running page 56. Now, this is dated, this is an alleged mortgage deed dated 13/5/06.
This
This
is
alleged,
after the amount was compounded.
yes.
So this
So after
mortgage deed was
compounding, Your Lordship,
yes.
after compounding the interest
Hmm.
and by adding 8 lakhs,
Hmm.
the total amount was raised to 70 lakhs.
Hmm.
Now, at page 56, this is the modified document. earlier, the amount
It was executed and signed by you also?
by plaintiff number 2 only, not by plaintiff number 1. May I read your lordship? I, Sri C. Amung Jamir, son of late so resident of Half Nagajan Dimapur, Nagaland, do hereby mortgage my land covered by Patan number 359, Dak number so, Moza number 1, Dimapur town, measure in so, with all the buildings and fixtures therein, herein after referred to as the said premises, at a consideration of which 70 lakhs, only at 6% interest per month to Sri Hukavi Muru Society and Society of Dimapur. The mortgage period is effective from 13 May 2006 to 14 January 2007, failing which I shall forfeit my said land to him. I agree to pay the interest every 2 months. I hereby deliver the original Jamabandi title deeds of the said land to him. That the said land is free from all encumbrances, such as litigations, attachment from decree or any other claims, and sign this deed in presence of the following witnesses, this 13 May 2006 at Dimapur.
This declaration was made by plaintiff number 2.
Number 2. Now,
So, what is the relation between plaintiff number 1 and 2?
they are
Here it appears
they
that
are-
plaintiff number 2 has taken.
uh,
Earlier plaintiff number 1 took.
no, 1 has
only.
taken. 2 is the guarantor.
2 is only guarantor.
He is the
But then here
guarantor.
it appears that the 2 is. Here this declaration is made by plaintiff number 2.
Number 2, because he has, since he is securing the value of the loan by mortgaging his property,
Yes.
he has signed this one. And so initially, in the same document, now the amount of 70 was 50, and the rate of interest was 8. But now, now reduced to 6, and the amount of loan was enhanced to 70 by the same document. And so the first loan was obtained on 13/5, 13/5/2006, and the defendant number, plaintiff number 2, signed on 13/5/2006 with the witnesses on 13/5/2006.
First document.
Yes,
And in the second document?
same. This amount of 50 was changed to 70.
So how in the same date?
That is why.
So there is a
So-
difficulty.
This amount 50 was changed to 70.
So only it appears that erase white fluid and then inserted.
Yes,
Instead of 50, made it 70.
70.
Instead of 8, made it 8, 6.
6.
So the date, signature, everything same.
Same.
So
That is why
where is the earlier document?
this is the same document.
No, where is the earlier document?
The-
The first document.
we have, with us, we have no other document. Now, why they have increased this 70, you lordship may kindly see at the back page of the same document. Back page. Received rupees 45 lakhs in check and rupees 5 lakhs in cash on 13/5/06. Now, initially, and rupees 20 lakhs was not there, but at the bottom, plaintiff number 2 signed, Among Jamir. So subsequently, after failing to pay the interest for 3 months, the defendant gave cash of rupees 8 lakhs, and by compounding that rupees 12 lakhs interest towards the principal loan amount, it was made 20 lakhs. And in between the first amount and the signature of plaintiff number 2, this was entered, and rupees 20 lakhs cash on 3/11/06. So on 3/11/06, the total amount of loan was enhanced to rupees 70 lakhs. And the rate of interest was reduced to 6% per month.
You see, this was signed on 13/5/06.
No fresh signature was obtained.
And then this we receive 45
45
lakhs and 5 lakhs.
45 was in check, 5 lakhs in cash.
This
This-
was on, okay, and rupees 20,000 case on 3/11.
Yes.
Okay, so
So now the contentions, at this time, let me just make a submission on this.
mm,
The contention of the defendant is that
mm,
on 3/11/2006, another amount of 20 lakhs in cash was taken, signed by the defendant number, plaintiff number 2. And that is,
other than this,
no, this one,
or this one,
this one.
okay.
Why they are saying that? Because plaintiff number 2 signed this on 13/5/06. But the allegation was that, the allegation of the defendant was that on 3/11/2006, a cash of rupees 20 lakhs was again given, which is also signed by plaintiff number 2, C. Amung Jamir. So they're trying to cover up the subsequent alleged amount of 20 lakhs said to have also been approved and signed by the C. Amung Jamir. But this and rupees 20 lakhs cash on 3/11/06 was inserted between the signature of C. Among when he put the signature on obtaining the first loan of 50 lakhs at the rate of 8% per month.
Okay, so this is inserted later on,
Yes,
according to you.
this was inserted later, certainly. Absolutely.
You are disputing this.
I'm disputing the amount of rupees 20 lakhs because even in my plain, both the plaintiffs stated that on 3/11/06, the amount of rupees 12 lakhs against interest, for interest, was compounded. And by giving another rupees 8 lakhs, making it 20 lakhs, the amount of loan was enhanced from 50 lakhs to 70 lakhs. As far as 50 lakhs is concerned, we are not disputing. But cash of 20 lakhs, we are disputing about that. We say that out of this, only 8 lakhs is in cash, and the rest, 12 lakhs, is compounded towards the principal amount, which was the interest for 3 months. Now, as per the rough calculations of the plaintiffs, a total amount of this 1 crore 16 thousand has already been paid to the defendant. However, the defendant is disputing about that one. The defendant admits only the payment of rupees 40 lakhs on 22 February 2008. That is the only admitted amount from the defendant side.
50 lakhs,
40. The defendant admits only payment of rupees 40 lakhs to him. Which was paid on 22 to 2008. Now, the trial court, without taking into account the evidence led by the plaintiffs, concluded that I'm still to pay 70 lakhs. And that after deducting the 40 lakhs. Now, how this 40 lakhs is to be deducted, the court has not given any indication or any direction. So after deducting 40 lakhs, I'll have to pay rupees to pay the defendant an interest of 14% per annum against this 70 lakhs. Now, as per evidence, I'll not claim now that I have paid 1,60,000, but as per evidence, clear evidence, unrebutted evidence, in addition to this 40 lakhs, I have paid another 22 lakhs, which I'll take your lordship to the evidence. I have paid another 22 lakhs, clear. So altogether, I have paid 62 lakhs, which cannot be disputed even by the defendant. And for that purpose, your lordship, I would like to take your lordship to the evidence.
so your loan amount was 50,
Yes, first was 50.
50 plus addition 12 lakhs plus
8 lakhs.
case 8 lakhs.
Yes,
So total is 70.
70.
70 you admit that you have taken.
If we are to accept the calculation of the contentions of the defendant, it is 70. But the point is now, 12 lakhs, the amount of 12 lakhs for interest for 3 months is compounded towards the principal. Now, legally, in this type of transaction, whether it can be done in that manner, and whether under the law, whether when the borrower paid some amount to the loanee, to the borrower, when the loanee deposited some amount to the borrower for deduction of the debt, the whole amount is never deducted against the interest only. Some percentage has to be deducted towards the principal amount, and the lesser amount will be adjusted towards interest. And the so-called mortgage agreement does not indicate if I failed to pay interest, say after 2-3 months, what will happen? There was no such agreement. In the agreement, it was not there. In the agreement with the guarantor. If there is no such agreement, the amount of interest cannot be adjusted at the whims of the borrower, at the whims of the defendant. And the trial court failed to consider this one. And Your Lordship, while making this, going through this mortgage, allowed me to make a submission on this. Now, this is a mortgage deed, but this is not a legally executed mortgage deed. Okay, this is not registered, this is not stamped. Even then also, I would not say that this is not admissible. It can be admissible for collateral purposes. But simply by admitting these documents in the court, it does not validate the validity of the documents itself. The validity of the documents has to be considered in terms of law. So for collateral purposes, if these documents admitted, let us say 70 lakhs, that's all. The rest, we cannot rely because the rest is not legally executed. For collateral purposes, if the defendants want to show that yes, amount of 70 lakhs was taken, then this can be taken into account. Although this document is not registered and not stamped, but this will not validate the whole contents of the documents. Therefore, however, the trial court has committed a grave error by concluding that this mortgage deed is valid. That is totally wrong, Your Worship. It cannot. It cannot. And now, Your Lordship, as I have submitted, in addition to that 40 lakhs payment made to the defendant, I have paid another 22 lakhs to the defendant. Now, why the trial court failed to consider this? Because there is ulterior motives. But now, if you see the evidence of the plaintiff on payment of rupees 12 lakhs and 10 lakhs to the defendant, the inescapable truth is the plaintiff has altogether paid rupees 62 lakhs. And in that respect, I would like to refer to page 114 of the paper book, 114.
Page
114. This is the deposition of Lily, numbered as witness number 3 at page 114. And I would like to go through her statements. May I read the Lordship?
Yes, please.
I, Mrs. Lily, aged about 43 years, wife of so-and-so, Duncan Basti Dimapur, in the district of Dimapur, Nagaland, do hereby solemnly affirm on oath and stated as follows, that it is in my knowledge that Mr. Toshik Pogba Longkumer and Mr. Siamang Jamir has filed a case against Mr. Hukavi Muru. The subject matter of the case is a mortgage where Siamang Jamir had mortgaged his land and building to Mr. Hukavi Muru for a loan consideration of rupees 50 lakhs at the rate of 8% monthly interest. That I and Mrs. Jano had arranged the loan amount of rupees 50 lakhs for Mr. Toshik Pogba Longkumer from Mr. Hukavi Muru, and Mr. Siam Jamir had given his immovable properties as a security for the loan and executed the mortgage with Mr. Hukavi Muru. 3. That after executing the mortgage, the loan amount was given in check to be drawn from the Bank of Baroda Dimapur. The check was accordingly encashed by me and Mrs. Jano from the bank, and the money was handed over to Mr. Toshik Pogba Longkumer and Mr. C. Among Jamir at former residence at Half Nagajan, Dimapur. That on 26/8/2006, Mrs. Hamu Longkumer, wife of Toshi Pogba Longkumer, handed over rupees 12 lakhs to me and Mrs. Jano towards payment of interest on the loan for 3 months, that is from 13/5/06 to 13/8/06, and for which I and Mrs. Jano issued a receipt. This amount paid, now this receipt was a receipt said to have been received the money from Mrs. Longkumer, wife of Toshi Pogba, issued a receipt. This amount paid interest was accordingly paid to Mr. Hukavi Muru at his 2.5-mile residence, Dimapur. However, no receipt was issued by Mr. Hukavi Muru against the payment, stating that the parties to the loan were maintaining their own accounts. That the receipt dated 26/8/06, 26/08/06, and my signature is exhibited as Exhibit P8 and P9. That I know the facts of the case to the extent as stated in the preceding paragraphs, and I verified this verification. Now in cross, it's a page 116. I am a housewife by occupation. It is true that Mrs. Jano arranged the loan for the plaintiffs. Both the plaintiffs approached to me personally for arranging loan to the extent of rupees 50 lakhs, and at that time, Mrs. Jano was also present in our midst. I do not know the exact name of those persons who acted as brokers in arranging the said loan. I have not charged any commission for the said loan. However, I do know whether any commission were paid to the brokers for arranging the said loans. It is known to the plaintiffs. The mortgage was created for the benefit of the plaintiff number 2. Maybe this is some mistake is there. However, plaintiff number 2 and 1. Number 2, and I signed, and 1 signed in the capacity of grantor. I can only say that the mortgage was signed by the plaintiffs. However, I have not seen the parties signing in the mortgage deed. I remember that 50 lakhs were given as loan to the plaintiffs. However, I don't exactly remember whether 45 was paid in cash and rupees 5 lakhs in check or vice versa. I say that the loan amount of rupees 50 lakhs were handed over to the plaintiffs at the residence of plaintiff number 1. It is correct to say that I have not seen the plaintiff number 2 within his signature on the back side of the mortgage deed, acknowledging the receipt. I have not charged any commission from the plaintiff for arranging the loan, but in place of other person's loan, I charge commission. I do not know for whose benefit the loan was secured by the plaintiff. However, I can say that the loan was for the purpose of both the plaintiffs. It is correct to say that the plaintiffs agreed to the interest rate of the defendant. I cannot say whether the interest rate is high or low. I do not know the subsequent loan of rupees 20 lakhs said to have been taken by the plaintiff number 2-3-11-06. I do not know the Zamabandi obtained in the name of another person by the plaintiff number 2 and making an attempt to secure further loan by mortgaging the said land again. This Exhibit P8 was issued by me and Mrs. Jano on 26/8/06 to the plaintiff and Mrs. Hamu while receiving rupees 12 lakhs from them. And I identified my signature exhibited as Exhibit P9. However, the defendant refused to issue receipt in respect of the said amount of rupees 12 lakhs paid on 26/8/06. I deny the suggestion that Exhibit P8 was prepared only after the institution of this case. I deny the suggestion that the defendant did not issue receipt for the said amount of rupees 12 lakhs as me and Mrs. Jano never handed over the said money to the defendant. I cannot say whether the mortgage deed is strictly enforceable. I have stated the true facts. I clarified in re-examination, I clarified that the interest towards the loan amounting to rupees 12 lakhs, which was received from the plaintiff on 26/8/06, was accordingly handed over to the defendant on the same day and further asked for the receipt of the repayment. However, the defendant refused to issue any receipt stating that since the repayment is only a part payment and the parties to the transactions are maintaining their own statements of accounts, and therefore it was not necessary to issue any receipt if the loan in question is fully liquidated. Now, there is the cross-examination. There is nothing to indicate that the defendant has not received this payment. There is nothing of that sort. Now, if we read the statement of the witness number 9, Mrs. Jano Kotu, at page 136. 136. She is as witness number 9. I, Mrs. Jano Kotu, aged about 46 years, wife of so-and-so, Signal Basti Dimapur in the district Dimapur, do hereby solemnly affirm on oath and stated as follows, that it is in my knowledge that Mr. Toshiko Palong Kumar and Mr. C. Amung Jamir has filed a case against Mr. Hukavi Muru. The subject matter of this case is a mortgage where C. Amung Jamir had mortgaged his land and building to Mr. Hukavi Muru for a loan consideration of rupees 50 lakhs at the rate of 8% monthly interest. That I and Mrs. Lily had arranged a loan amount of rupees 50 lakhs for Mrs. Toshipok Balongkumar, Mr. Toshipok Balongkumar from Mr. Hukavi Muru, and Mr. C. Among Jamir had given his immovable properties as a security for the loan and executed the mortgage with Mr. Hukavi Muru. That after executing the mortgage, the loan amount was given in check to be drawn from the Bank of Baroda, Dimapur. The check was accordingly encashed by me and Mrs. Lily from the bank, and the money was handed over to Mr. Toshipok Balongkumar and Mr. C. Among Jamir at former residence at Half Nagajan, Dimapur. That on 26/8/06, Mrs. Hamul Longkumer, wife of Toshi Pogba Longkumer, handed over rupees 12 lakhs to me and Mrs. Lily towards payment of interest on the loan for 3 months, that is from 13,506 to 13,806, and for which I and Mrs. Lily issued the receipt. This amount paid as interest was accordingly paid to Mr. Hukavi Buru at his 2.5 mile residence, Dimapur. However, no receipt was issued by Mr. Hukavi Muru against the payment, stating that the parties to the loan were maintaining their own accounts and receipt would be issued only after final clearance of the loan. That I know the facts of the case to the extent as stated in the preceding paragraphs. I verify and in cross-examination. I'm here today as a witness of plaintiffs. In page 138, I am unemployed and I am a housewife. For arranging the loan, no commission was paid to any by the plaintiffs. For obtaining the loan of rupees 50 lakhs from the defendant for the purpose of plaintiff number 1, then plaintiff number 2 mortgage his land property as security for the said loan. I have not involved in such loan arrangement before the present loan transaction. The exhibit D1 was executed at the residence of defendant. However, I have not signed at the said document, though I was present while the plaintiffs and the defendants were executing the said exhibit. The date of execution exhibit D1 is correct. It is correct that the amount of loan was transacted by check of rupees 45 lakhs and 5 lakhs cash. I do not know the subsequent loan transaction amounting to rupees 20 lakhs and rectification of the said mortgage deed on 3/11/06 by the parties. I do not remember who prepared money receipt on 26/8/06, exhibit P9. However, the signature appearing bearing serial number belongs to me. I am certain that the said money receipt, exhibit P9, was not by the defendant. I deny the suggestion. The amount of rupees 12 lakhs was not paid to the defendant on 26/8/06. Though the amount of rupees 12 lakhs was handed to the defendant, yet the defendant refused to issue money receipt, saying that the accounts are maintained by the parties and it can be worked out at a final payment. So here, a little more, page 139. I have never faced such a situation on earlier occasion. I deny the suggestion that the said amount of 12 lakhs was paid to me and Mrs. Lily towards our commission for arranging the said loan. I deny the suggestion that the money receipt exhibit P9 was prepared by me and Mrs. Lily and the wife of plaintiff number 1 only after institution of present suit. I know only about the initial loan of rupees 50 lakhs advanced by the defendant to the plaintiff and about the interest of rupees 12 lakhs paid to the defendant on 26/8/06. I am known to the plaintiff number 1 and his wife since more than 20 years, and we are family friends. I have stated the truth facts which I know. In re-examination, I clarify that the amount of 12 lakhs which was given to me and Mrs. Lily by the wife of PW number 1 on 26/8/06 was accordingly handed over to defendant on the same evening at his residence sitting room, who however refused to issue any receipt for the payment received, stating the parties to the transaction are maintaining respective account and it was not necessary to issue a receipt. Now in cross-examination, a question has been put And this was a suggestion at page 139, second line of the cross-examination. I denied the suggestion that they said the amount of which 12 lakhs was paid to me. I'm sorry, not that one. At page 138, second line from bottom, I deny the suggestion that the amount of 12 lakhs was not paid to the defendant on 26/8/06. This is by way of a suggestion. And since this is by way of suggestion, once a suggestion is denied, it has no value. This cannot be taken into consideration and to say that no, 12 lakhs has not been paid. This is corroborated by the earlier witness number 3, Mrs. Lily. So it is clear, no doubt, that 12 lakhs has been paid to the defendant, although the defendant is denying, but evidence shows that he has been paid rupees 12 lakhs interest for the first 3 months after availing the loan of rupees 50 lakhs. The trial court failed to consider this. The trial court failed, in fact, to consider the evidence of the plaintiff's witnesses. Now, therefore, in conclusion, my submission is that 12 lakhs have been already paid in addition to that first 40 lakhs, which is admitted by the defendant. So now together 52 lakhs. Now, another 10 lakhs was paid to the defendant. And for that,
50 plus 12.
40 lakhs payment was not disputed by the defendant because he was compelled to issue a receipt on that day in presence of several family members of the plaintiffs as well as some relatives of the defendant. He was compelled, otherwise he was not going to issue. So, in addition to the admitted amount of rupees 40 lakhs repayment, now plaintiff number 3 and witness number 3 and 9 has proved the payment of rupees 12 lakhs. They corroborate each other and they corroborate the statements of the plaintiffs, which the defendant failed to rebut. Now, another rupees 10 lakhs was paid to the plaintiff. To the defendant. And for that, I would like to take your lordship to PW number 6 at page 126. This is page 126. This is the statement of one Mrs. Areng Nungla, witness number 6. I, Mrs. Areng Nungla, age about 43 years, wife of Mr. Meran from Kumarasonso, District of Dimapur, Nagaland, do hereby solemnly affirm on oath and state as follows: that it is in my knowledge that Mr. Toshipok Balongkumar and Mr. C. Among Jamir had filed a case against Mr. Hukavi Muru. The subject matter of the case is a mortgage where Mr. C. Among Jamir had mortgaged his land and building at Half Nagajan to Mr. Hukavi Muru against a loan. That on 2108, I was asked by Mr. C. Among Jamir to accompany him to the residence of Sri Hukavi Muru at 2.5 Mile Dimapur. I was informed that the purpose of the visit was to repay rupees 10 lakhs to Mr. Hukavi Muru against the loan, which he and Mr. Toshipok Balongkumar had secured from Mr. Hukavi. The amount of rupees 10 lakhs was paid to Mr. Hukavi in my presence and in the presence of Mr. Imotila, After making the payment, we requested Mr. Hukavi to issue a receipt, but he refused to oblige, stating that both the parties to the loan were maintaining their own account against the repayment and the receipt will be issued only after the loan is fully clear. That I know the facts of the case to the extent as stated in the preceding paragraphs. Then next is verification. Now in cross-examination at page 138. I'm sorry. No cross-examination, Your Lordship, here. No cross-examination. So this is admitted facts. As plain and simple as that. No cross-examination. However, in this connection, we may also see the statement of Imotila PW4 at page 118. 118. I, Mrs. Imotila, age about 39 years, wife of so and so, half Nagajan Dimapur in the district of Dimapur, Nagaland, do hereby solemnly affirm on oath and state as follows. That it is in my knowledge that Mr. Toshipo Palongkumer and Mr. Siamu Jamil has filed a case against the same thing. So from paragraph 2. I am the younger sister of Mr. Toshipo Palongkumer. 3. That on 21/01/08, Mrs. Lamu Longkumer, wife of Mr. Toshipo Longkumer, gave me rupees 10 lakhs, asking me to hand over the money to Mr. C. Amung Jamir. I accordingly handed over the money to him. Thereafter, on the same day, Mr. C. Amung Jamir asked me and Mrs. Aranglungla to accompany him to Mr. Hukavi's residence to pay the amount to Mr. Hukavi Muru against the loan obtained by Mr. C. Amung Jamir and Mr. Toshipo Jamir. This amount of rupees 10 lakhs was paid by Mr. C. Among Jamir to Mr. Hukavi Muru in my presence and that of Mrs. Aranglungla. After making the payment, when we insisted on the receipt of Mr. Hukavi Muru, refused to give the receipt by conveying that as both the parties to the loan agreement were maintained their own accounts against the repayment, it was not necessary to issue the receipt. Then I know the facts of the case to the extent as stated in the preceding paragraphs. And page 1 is the verification, and cross is at page 120. I am a housewife by occupation. I am the younger sister of the plaintiff number 1. My husband is a government servant, presently serving as Assistant Director, Printing and Stationeries, and posted at Dimapur. I have heard about the involvement of plaintiff number 2's property by way of mortgage while securing loan from the defendant. I do not know about the involvement of amount in the said loan except the payment of rupees 10 lakhs paid through me. I don't know anything besides that. I deny the suggestion that the amount of rupees 10 lakhs was not paid to the defendant on 21/1/08 by me and plaintiff number 2. I deny the suggestion that the sum of rupees 10 lakhs was handed over to me by the plaintiff on 21/1/08. I met the defendant for the first time on 21/1/08. On 21/1/08, the plaintiff number 1's wife was not feeling well. As such, I was entrusted to hand over the money to the plaintiff number 2. The amount of rupees 10 lakhs handed over by me to the plaintiff number 2 were denominations of 1,000 notes. No receipt was issued in respect of the said 10,000 by the defendant, 10 lakhs. I cannot say what type of business the plaintiff number one is engaged with. However, I know that he does business. The plaintiff number two and the wife of plaintiff number one requested me to stand as a witness in this case. I have not met the defendant after 21-108. I deny the suggestion that Mrs. Arang Mongla was not with me and the plaintiff number two when the said sum of rupees 10 lakhs was paid to the defendant on 21-108. The amount of rupees 10 lakhs was handed over to me to pay to the defendant towards the loan secured by the plaintiffs. I cannot say who utilized the money taken on loan by the plaintiffs. It is correct that the plaintiffs had admitted having obtained loan from the defendant. I deny the suggestion that the wife of plaintiff number one did not hand over to me the said sum of rupees 10 lakhs to be handed over to plaintiff number two. On 21-108, the plaintiff number one was out of station. I do not remember the exact time of my visit to the defendant's place on 21-108. However, it may be around 2 to 2:30 p.m. I do not know from where the said sum of rupees 10 lakhs was arranged. Mrs. Arang Mongla is a cousin sister of the plaintiff number two who resides at 2.5 miles. I have never involved in handing over such a big amount before this transaction. Now in re-examination, it is correct to state that on 21-108, when I along with the plaintiffs number two and others went to the residence of the defendant, it was the plaintiff number two who handed over the sum of rupees 10 lakhs to the defendant, and the plaintiff number two, on asking for the receipt of the defendant, replied that it was not necessary to issue the money receipt as both the plaintiffs and the defendants were maintaining their own account on the loan. I was asked by the plaintiff number one and his wife, Mrs. Lamu, to stand as a witness in this case, as I was told that the defendant was denying receipt of rupees 10 lakhs, which the plaintiff number two had paid to the defendant at the latter's residence on 21-108, where I was also present. And recross, the other lady, cousin sister of plaintiff number two, correct name is Aran Menla and not Arang Mongla. So here also, there is only suggestion. Suggestion that he has not received the 10 lakhs. You have not paid to the defendant the 10 lakhs. Suggestion. As I submitted, suggestions once denied loses its value. Now in this connection, we may also see the statement of C among the plaintiff number two at page 86. Since we're at this point dealing with the payment of 10 lakhs, I'll come direct to the this 10 lakhs amount for the time being. Paragraph 7 of the deposition of plaintiff number two at page 86. Relevant paragraph is paragraph 7 at page 87. Paragraph 7, that on 21-08, Mrs. Lamu, wife of plaintiff number one, handed over an amount of 10 lakhs to me for repayment against the loan. Accordingly, I, along with Mrs. Imotila and Mrs. Aran Mongla, went to the residence of the defendant and then handed over the amount to the defendant. Absolutely corroborated. Then the encroach. At page 198, the questions raised to this plaintiff in cross-examination. Now, relevant portion for this 10 lakhs is at page 98, fourth line from the just above the re-examination. And this is also by way of a suggestion. I deny the suggestion that the transaction of rupees 10 lakhs was not made with my knowledge. So he has denied the suggestion that it was not made, it was made with his knowledge. The question is also not of payment, not paid. That is also not the suggestion. The suggestion is payment of rupees this 10 lakhs was without your knowledge. That was the suggestion. But he says, no, it is with my knowledge. In his chief examination, he has stated, corroborated by Mrs. Mongla and Mrs. Imotila. Therefore, clearly, in addition to that admitted amount of 40 lakhs, I have paid rupees 22 lakhs addition to the defendant, altogether rupees 62 lakhs out of the so-called 70 lakhs. Let us make it 70 lakhs. But the trial court have to consider whether this subsequent loan of amounting to rupees 20 lakhs was all by cash or 8 lakhs in cash and 12 lakhs was compounded as principal. The trial court failed to discuss on that. And only seeing the signature of the plaintiff number 2, C. Amung Jamir, signed on 13/5/06, the court says that yes, he has put his signature, which is the so-called agreement. Now, conclusion of the trial court is totally wrong and illegal. Let me take your lordship to again that document at page 56, running page 56 on the next page. All the parties sign on 13/5/06, including the two witnesses, Toshilong Kumar and Boto Su. None of them were examined by any party. And Amung Jamir was also signed on 13/5/06. And this about 20 lakhs was inserted on 3/11/06. The trial court have not considered these aspects and concluded that yes, there is a signature among which cannot be denied. And he is not denying his signature because his is his signature. And this signature was appended on 13/5/05 when he's handed over his original pata to secure the loan of rupees 50 lakhs for plaintiff number 1. And therefore, again coming back to this mortgage, so-called mortgage, the only purpose, collateral purpose for which this mortgage deed can be used by the court or by the party is only to show maybe the signature of the appellant, signature of the defendant, and the amount borrowed. And about the conditions, the subsequent conditions, which I shall forfeit my said land to him, or that the amount of interest. This cannot be taken by the court. The court cannot take cognizance of the other conditions because this is not a legally executed document. And therefore, it is totally illegal and erroneous on the part of the trial court to say that this is valid document. Now, Your Lordship, if this is a valid document, then what will be the consequence? Because the trial court says this is a valid document. However, the court, in fact, has not taken into consideration the rate of interest of 6% per annum or 8% per annum. Now, Your Lordship, if we are to consider that this document is valid as contended or concluded by the trial court, we have to take the interest rate of 6% per month, which is 72% per year, 72% per annum. Will that be legal? That would be immoral, in fact. That will be immoral. And therefore, the conclusion of the trial court is totally wrong because the trial court decreed that I should pay rupees 70 lakhs. Now, let me take Your Lordship to page 2 of the paper book. In the first paragraph, I have quoted the decree. Page 2. Decree.
This is?
This is decree.
Yes.
I have quoted the decree passed by the trial court. Decree, in terms of the aforesaid judgment and order passed, it is hereby ordered and decreed as follows. The mortgage deed dated 13/5/05 and modified on 13/6/06. The first one, 13/5/05, is not correct. It should be 6. 13/05/06. This typing mistake. And modified on 13/11/06 is valid and enforceable. Second one is the defendant is entitled to recover the outstanding loan amount from the plaintiff together with 14% simple interest per annum with effect from 13/5/06 to 2/11/06 on principal amount of rupees 50 lakhs and thereafter on enhanced principal amount of rupees 70 lakhs with effect from 3/11/06 till full and final realization after adjustment of rupees 40 lakhs paid on 22/2/08 towards the loan. That is the decree. Now, Your Lordship, here, the illegality also is writ large. The first is the defendant is entitled to recover the outstanding loan amount together with 14% simple interest per annum with effect from 13/5/06 to 2/11/06 on principal amount of 50 lakhs. This is also illegal. Illegal because now 14% per annum. This is excessive. The court, yes, granting of interest is at the discretion of the court. But the court never grant interest at this rate of interest. It always consider the existing rate of interest exercised or given by the State Bank of RBI. And so there also there will be different rate of interest. For loan also there are a lot of different types of loans. House loan, car loans, other loans, study loans, all are different, not same. And it never exceeds 7 or 8% per annum. Then fixed deposits. Fixed deposit also now at this rate, at this time, for the senior citizens, for a little less than 1 year, I think it is around 7% something, not even 8%. And for current account interest, it is hardly 2%, or a little more than 2% existing rate. And therefore, the court, under what circumstances the court has granted this 14% simple interest per annum? This is exorbitant. The other factor is now for 70 lakhs at the rate of 14% will be effective from 3/11/6 till full and final realization after adjustment of 40 lakhs paid on 22/08 towards the loan. Now, this is totally illegal again. In terms of the law, in terms of the provisions of the CPC, after the decree, the court cannot grant interest beyond 6%. But this one is 14%, even after the decree, till realization of the amount. So this decree, this judgment, this order of the trial court cannot stand in any view of the matter. The other point is, now the court says, after adjustment of 40 lakhs, only 40 lakhs. Okay, for the time being, let us take 40 lakhs, the undisputed amount. How this is going to be adjusted? Who is going to adjust? There is no direction for the parties to adjust this one. Against which? Against the principal or against the interest? Now, all the repayment made was adjusted against the interest by the defendant. Therefore, if this is 40 lakhs is to be adjusted towards the interest, how the plaintiff is going to repay his debt for the remaining debt? He has to be declared himself or approach the court for insolvency. The next is, now the trial court failed to consider the fact that there is clear evidence that another 22 lakhs have been paid, 12 lakhs plus 10 lakhs. The trial court failed to consider that part of the matter totally. And therefore, in any view of the matter, on that score alone, rate of interest and the adjustment of the 40 lakhs amount and non-consideration of the receipt of 22 lakhs by the defendant or received by the defendant and failed to consider by the trial court, is sufficient ground or are sufficient grounds to set aside the impugned judgment. Now, Your Lordship, the plaintiff has filed the suit for recovery of his original pata because according to the plaintiff, they have paid more than sufficient to the plaintiff. According to their calculation, they have paid 1,60,000 to the plaintiff. And therefore, the plaintiff has filed a suit for reopening of accounts, readjustment of accounts, for return of the secured original pata and others. And also for exorbitant rate of interest. Now, in the counterclaim, the plaintiff has, the defendant has claimed rupees 1,38,80,000, no? Counterclaim. In the counterclaim, the defendant claimed for 1,38,31,80,000. Of course, this total amount has not been granted. And his calculation is at page 53.
Counterclaim is it?
Yes, page 53. His prayer portion.
Counterclaims, prayer in the counterclaim,
Yes,
page 53.
page 53.
This is
Page 53,
written statement for an.
paragraph 41, Your Lordship. Therefore, the defendant prayed the following decree. A decree for rupees 1,31,80,000, and this is the amount is rupees 70 lakhs plus rupees 61,80,000 interest. So together, 1,31,80,000. And the interest calculation is at the rate of 6% and also 8%. Now, rate of interest, here I would like to make my summations of rate of interest. Rate of interest.
This written statement, this written statement is okay, counterclaim.
Yes, written
Under-
statement
okay,
in the written statement
counterclaim,
made.
okay.
Yes. So, in our plan, as well as in this counterclaim statement, we said exorbitant rate of interest. And how a person can judge the exorbitant, whether a rate of interest is exorbitant or not? The Usufructual Loan Act itself says that the rate of interest itself will show whether it is exorbitant or not. And now the defendant is claiming interest at the rate of 6% per month and 8% per month, which comes to 96% per annum and 72% per annum. Whether it can be considered as exorbitant. Certainly it is exorbitant. There is no question to argue about it. Okay, in some cases, outside the court, somebody may be claiming exorbitant rate of interest monthly, but when the question comes before the court has to consider whether it is against public conscience, whether it is permissible or not within the framework of the law, and whether it violates the principles of law laid down. We cannot say that, yes, in the past we have been doing like this. That will not be sufficient defense to charge exorbitant rate of interest at the rate of 72 and 96% per annum. And therefore, the rate of interest is granted by the court is also not permissible under the law. Then how do you adjust this 40 lakhs? Not only that, why the trial court failed to consider the payment of rupees 22 lakhs by the plaintiff to the defendant? Those are yet to be considered again. The other factor is now on 21/108, we have paid rupees 10 lakhs, which is not disputed now. And on 22/208, the defendant has left his draft account in the residence of the GB, Chukjim Jamir, PW number 7. And that, where is it, draft account, page number? What does it? Page 44. Page 44. This is, we contend that this calculation of amount, the balance amount, has been prepared by the defendant. And this was kept in the house of the GB of their colony, Mr. Chukjin Jamir. And telephonically informed Chukjin Jamir, when at the point of time he was at Kohima, that he left his rough account in his residence. Now, how this has come into the issue? Now, the next page, page 45. This is the receipt issued by, written by one Piketo and signed by Hukavi. On behalf of Hukavi, he issued this, he wrote this, Piketo wrote this receipt. And so the receipt of 40 lakhs, this is not disputed, but why the rough account purportedly issued by the defendant has become an issue? Because the writings of this and the receipt is very similar. Is very similar. So the court has sent samples for forensic opinion. The samples taken by the court is page samples taken by the court.
It's 150.
150, 151, 152, 53, 53, 151, 152, 53, 54 from 150. These are said to be specific specimen handwriting of Picketo. 145, 150, 151, 152, 153. Now, the opinion of the expert is at page 157. 157. May I read the receipt?
Yes.
The documents in connection with an inquiry received by civil suit number 13, 2000, dated 16/7/2012, have been carefully and thoroughly examined and compared with the supplied standard writing from the original document in all aspects of handwriting, identification, and detection of forgery with the necessary scientific aid available in the Director of Forensic Science, Assam, Gauhati, 19. The red enclosed question writings and signature stamped and marked Q1 and Q2 were examined and compared with the blue enclosed writings and signature stamped and marked S1 and S2 in a number of sittings. But it has not been possible to express a definite opinion regarding the authorship of the red enclosed writings and signature stamped and marked Q1 and Q2 on the part of comparison with the materials at hand. However, another attempt will be made to form a definite opinion in this case if some more specimen writings of the connected person obtained by dictating him to write the text similar to the question document on different sheets of paper with very fine speed, along with, if possible, soon some admittedly genuine writings of the same person written by him in his normal course of business during the period 2007-2009 may be sent with these documents for comparison. Now, the expert's opinion is this one. They could not, at this point, with the submitted documents, they cannot make a definite opinion. And in order to give a definite opinion, now more specimen handwritings of the person as described here should be provided. But now the trial court has simply concluded that the opinion of the expert was in the negative. It is not in the negative. The trial court is supposed to give more evidence, more specimen handwritings with varying speed, with his admitted writings to the experts for a final opinion, for a definite opinion. And why did the court fail to do that? Because from the statements of the defendant. Now, this Picato, who was made a court witness, seems to be a member of their society, which is not registered. It is not a registered society, where this defendant also may be a member, and where this Picato is, if I'm not wrong, I think he's secretary or something in the society. So his admitted residence can be obtained from there. But the court failed to do that. And your lordship, now I just found, I detected something. Your lordship has asked earlier about the first mortgage deed, which is at page 56. And this is the second one. Second one means which was entered on 13, entered on 3/11/06 by enhancing the amount to 70 lakhs, reducing the rate of interest to 6 lakhs. And your lordship has asked, where is the first 50 lakhs?
Original.
Yes. Now, original, I don't know, but the first one, XB D2, your lordship may now kindly see page 55. This is mortgage deed, same date,
No,
13/5.
55 is affidavit.
Yes, but amount is 70.
Hmm?
Amount is 70.
No.
Interest rate is 6. But
55, page 55.
155.
Okay, 155.
Yes.
Okay, just a minute. Yes, here again.
Yes. Amount of 70 is same. Interest rate 6% is same. But turnover, your lordship.
Just a minute.
Same documents, nothing changed. And
So here again,
receive
76%. No, this is same.
uh,
Same with the,
same. In the first page it is same.
yes.
But on the back page,
Okay.
receive rupees 45 lakhs in check, 5 lakhs in cash, see among Jamil. At this time, there is no that rupees 20 lakhs.
No, and rupees 20 lakh cash
Yes,
on 3/11.
yes.
There.
That was not there.
Hmm?
This is not there. That one is not here.
No, this is there.
No,
It's same.
same.
Yes, it's
Same handwriting, but 20
No.
lakhs cash is not there.
No, it's there.
No.
And rupees 20. I have the copy which it has.
Page 155.
Yes. 155.
Yes,
Oh, 156, I thought.
155.
155. Oh, it's
Back page.
back page.
See, 20 lakhs is not there.
Just a minute. No. Oh, yes.
And in page 156, back page, your lordship has seen, it is there. 20 lakhs cash. But in this, it is not there. Because this is the first one. While obtained in 50 lakhs. Where the plaintiff number 2, C. Among Jamir, signed. Among C. Among Jamir. Therefore, in between rupees 45 lakhs and 5 lakhs cash and the signature, subsequently an amount of rupees 20 lakhs cash on 3/11/06 was entered. And now they claim that C. Among has received in cash this 20 lakhs. Because C. Among is not disputing his signature. He is admitting that is his signature. Because it is his signature. This is a manipulation. That is why we are saying that only 8 lakhs was given in cash, but 12 lakhs was compounded towards the principal. 12 lakhs interest was compounded towards the principal of 50 lakhs, making it 62 lakhs, and by giving 8 lakhs cash, it was raised to 70 lakhs. Because of this, the defendant is contending that no, we have paid 20 lakhs in cash, which is false. Page. Page. And Your Lordship, this for that account, rough account prepared by the defendant.
This document was annexed by this without this 20 lakhs
By the
and rupees 20 lakhs case.
Marcus exhibit D1, who submitted? Some are, these documents, some are submitted by the plaintiff, and I think some are by the defendant.
Because on the back page, wherever there is a 20 lakhs
Yes.
paid in cash, probably are the document submitted by the respondent, defendant. And then this document probably, which doesn't have that, is printed.
20, page
Yes,
155.
without this 20 lakhs, probably is annexed by you.
Unless I go through the depositions, I'm not sure, but
So the exhibit, it was exhibited by exhibit D.
exhibit D2,
D1 printed both sides. So this is would be yours. Oh, this D means defendant. No, it is D only.
no, D is defendant. And P is the plaintiff.
So this was
by defendant.
this is by defendant.
Yes.
So in his own document, uh, but you are otherwise ready to repay with reasonable interest.
Repay with reasonable interest after deducting the money already received by 40 lakhs plus 22 lakhs.
So that should be
And how to
deducted.
adjust,
That should be deducted.
that should also be deducted.
Uh,
But how that is to be deducted? Now together it be 62 lakhs. How is to be adjusted? Should it be adjusted towards the only against the interest? They will be totally arbitrary. And out of that 62 lakhs, how much should be deducted towards the principal? And interest, then at what rate of interest? It can never be
this
40.
it appears is case to be negotiated
Your Lordship, negotiation,
through arbitrator.
if they can be, but I don't know whether the parties will be able to.
Because this calculation, again, it will be put in trouble to the court also to calculate from which date the interest is to be
No,
calculated. and
interest,
for how much
Your
amount.
Lordship, that is no problem.
First is to be
Because
given how
As,
much interest.
as I've submitted during the last time.
Uh,
Now, if there is an agreement between the parties
uh,
prior to the institution of the suit,
uh,
then the court can take into that
Okay.
rate of interest,
Okay.
but which is legal, which is valid or executable rate of interest. That is one. Now, from filing of the suit till the decree is passed, the court can grant rate of interest, which has to be governed by the rate of interest as per the nationalized banks.
That can be, of course, but then from
the date of filing of the suit to the date of passing the decree, in between. Then, from the passing of the decree till the repayment of the decretal amount, it cannot exceed 6% in terms of section 34 of the CPC.
Okay. Okay. Can we today I have a meeting also, and then a brief is to be seen. Can we continue tomorrow?
Okay. Yes.
Tomorrow. No?
Yes. Yes.
No. Tomorrow. No, sorry. Tomorrow, of course,
Tuesday.
can be Tuesday.
Yes.
Call. No?
Yes.
Call here. Yeah?
Is there?
Yes.
So.
Mr. Aragalo, Lana Senior Advocate, assisted by Miss Mabani, Mabeni, and counsel for the affiliate staff. I've also Mr. N.K. Lukam, and counsel for the sole respondent staff. As agreed upon by the Nana Council for the party, list this matter again tomorrow on that is 21 for further hearing.
Part heard, Lordship.
It is part heard only.
Yes. Obliged.
Any other matter? No. Okay.
I will.
I will like
তাকে কোড নম্বর 1 তে দুইটা হিয়ারিং আছে, আমি জাস্ট মেনশন